FBI versus Fakre. Okay, I hope I'm saying the name right. By the way, this case sounds like a movie. So let me read you the case. Jonas Fakre is an American and a Sudan immigrant who traveled to Sudan in 2009 from Portland, Oregon, his home. When he tried to return to the United States, he was notified by the FBI that he was on the no-fly list. Fakre asserts that he was placed on the no-fly list unconstitutionally. The FBI asked him extensive questions about the mosque he attended in Portland, and they offered him to get off the no-fly list if he became an FBI informant. Fakre refused, and he then traveled to the UAE, where he was interrogated for 106 days under the request of the FBI. Since he could not return to the United States, he flew to Sweden and stayed until 2015. He has filed suit against the United States because he claims that he was placed on the no-fly list based on his race, country of origin, and religion. In 2016, he was notified to be off the list. The government states that since he was removed from the no-fly list, then this case is moot. The larger questions are this. 1, how much information should the government provide in order to justify placing individuals' names on the no-fly list? 2, what is the procedural due process for government agencies versus civil liberties? The unanimous decision is that the government is to provide evidence that this is a moot point. Removing Fakre from the no-fly list does not make the case an automatic dismissal. Gorsuch wrote the opinion. Due to September 11, 2011, the no-fly list expanded. By 2016, there were 81,000 names on the list. This was a procedural violation, as the FBI did not inform Fakre the reasoning for being on the list and the process for being removed. When he was removed, there was no explanation. Even though there was a wider range of liberty for FBI agents, because of the circumstances after September 11th. The courts have limited ability to evaluate cases and controversies. Yet, the defendant cannot automatically moot a case. In order to moot a case, then the defendant must demonstrate a lawful end with reasonable expectations. These expectations have not been met. Just because the federal government has not demonstrated enough evidence to declare this a moot point to dismiss the case, it does not mean that they could not do so in the future. Alito writes a concurrent opinion, but Alito asserts that the federal government does not have to disclose classified information. The government still has the utmost responsibility to keep everyone safe. Implications. The Supreme Court really did not give individuals many more rights, but it does mean that government agencies must start having a procedure for placing people on the list and removing people from the list. Yet it cannot be too much information because the government can still state it is a national security risk to provide too many details. Thus, can certain groups be targeted for further investigation? Sadly, yes. But there still needs to be due process.